very much. So, following on from Frederick's very, very useful and very good presentation on data protection in the here and now, what I'm planning to do is look at the interaction between intermediaries, in inverted commas, and data protection, but from a historical perspective. Not a historical perspective going right back to classical times, as this lovely image from the French Data Protection Authority might imply, but at least a historical perspective going back to the era when the sort of images we saw online looked like this lovely fellow on the left and were rather less disclosive than the sort of images that, say, Max Mosley gets rather hot under the collar about. Okay, so I'm going to make 4 key claims and try and provide the evidence for them. The first is that I'm going to argue that right from the beginning of European data protection, this idea of control and being a controller was both broad and it needed to be looked at on a granularized basis. What particular types of processing impacted data subjects, natural persons, in a way which was potentially illegal rather than legal, on granular rather than overarching basis. The second is I'm going to look at the e-commerce directive's data protection provision again. This is sort of fast forwarding 10 years from that lovely image, and say that as originally drafted, that provision was indeed meant to mean that if you are a controller, then you're outside the ECD. Why? Well, how can you be an intermediary and also be a controller? These are chalk and cheese concepts. And as regards the internal market clause of the e-commerce directive, well, the directive of data protection had already provided that internal market anyway. So there was no work for the e-commerce directive to do. However, as the negotiations on the e-commerce directive went on, and in the latter stages of them, in the late 90s, ambiguity arose as to what so-called active hosts' position would be. Not so much search engines, but at least active hosts like bulletin board systems and the like, which may have some resemblance to social networking sites and things like that today. So my sort of conclusion will be that data protection does clearly have a key role in regulating intermediaries, active intermediaries. However, and this will fast forward to the present, the GDPR changes do, I think, point to, building on that ambiguity, active hosts having some kind of protection within the hosting safe harbour, and they also flag up very usefully the general issue of freedom of expression, the general need for a reconciliation with freedom of expression, and that includes issues to do with the ambit of responsibility of actors, not just the substance. Okay, so those are the 4 key claims. Now I'm going to have to try and show you that they may have some validity. So looking at the issue of broad control first, let's return right back to the 1980s and to the Minitel system. I'm sure I don't need to tell you, the Minitel system was the first mass online system with millions of people around France in the 80s using these terminals. And although online systems, even though we're two-way, were originally thought to be primarily informational in nature, the end user would interact with the system, but by and large to pull up information that they were particularly interested in. It became clear, even by the mid-80s, that actually what users found most interesting was to engage in certain forums which were targeted to allow them to speak, to allow them to say things within a certain context. And boy, did they start saying things. There were accusations made about others, there was defamation, there was identity theft, and even in the 80s this resulted in a sort of policy debate about what was going on, what were the responsibilities and liabilities here. The most infamous example which came to light involved Le Minitel Rose, the early online dating site, which allowed people to publish, no photos of course, but publish dating profiles. And what was happening was that people thought it would be a laugh to put up details, Ms. X is looking for, or Mr. Y is looking for, clearly with real names, totally falsely, including their telephone number and sometimes even their physical address. And obviously these people were getting telephone calls multiple times. They were even having some people visiting them at their house looking for a certain sort of liaison, which maybe they weren't looking for at all. The important thing when we come back to data protection is that the French Data Protection Authority maintained that these forum owners, in setting up a dating site, had data protection duties. They were determining the purposes and means in broad terms of the processing. They had to ensure data protection was adhered to. So, for example, the Minitel Rose, they said, forum owners must ensure that no telephone numbers, no addresses were published in any way on the forum without the owners obtaining, without the consent of the telephone owners. In other words, prior restraint. They had to see that the message contained that, monitor it, ring up the person to see whether it was genuine, and only then publishing it. And they even argued that if they negligently failed to do that, they would be criminally liable under the law, which says that if you allow the disclosure as a data controller, they don't even bother mentioning the word data controller, but you allow the disclosure of data undermining reputation or intimate life, you are criminally liable if that is with negligence. So very, very broad consideration of control there. The granularity of control, I think, is shown, again, if we want to go way back, and I think it's always fun to go way back to the early days of how systems are considered, to the regulation of databases, online databases. And online databases were actually quite prevalent, even in the mid-1980s. There was a survey done which suggested that there were at least around 3,000 of them by the mid-1980s. Some of which wouldn't contain personal data, but many of which would. To be fair, I would think that probably most of them managed to escape data protection regulation entirely. Remind you of anything? Many of them, to be fair, because they were entirely outside Europe, but I think even the ones which are inside Europe, by and large, managed to go under the radar screen and escape legal analysis. However, the few which did come within the headlights of the Data Protection Authority were often subject to really quite rigorous control, and control which did indicate the need for a granular analysis of what was going on. So in 1981, the Swedish Data Protection Authority even sought to regulate a legal database which was going by the name of Rättsdator, which was simply a list of cases and the publication of Swedish cases. They argued that the database was the data controller of that database, and they put a requirement on it not to ensure that the processing operation didn't allow any name searches to be conducted at all on that data. Not even of judges, in fact, which is quite incredible, really, but certainly not of claimants, and really quite strict conditions put in place to ensure that really was, in a disciplined way, adhered to. Now, I'm not defending the substantive finding, or indeed any elements of these findings necessarily, but what's interesting with an echo of Google Spain here is that it was granularized. It's fine to have the data there, it's not fine to have name searches. That's too intrusive. That's too much like building up a profile on individuals. And this concern about the right to be forgotten, actually, and this was a term which was expressly used even in this era, and the need for granularity of analysis to prevent a never-ending present for anyone, however irrelevant they are to public debate, was even found in the regulation of external digital archives of newspapers in the Scandinavian countries in particular. So, for example, in Norway, the license conditions which are put in place required any such database to remove reference to identified individuals convicted or otherwise involved in criminal acts after 7 years, right to be forgotten, with the only exception being if the subject was named in relation to that offence as an occupier of essentially a public figure type role. Okay, so all of these things, I hope, are, albeit in a totally changed socio-technological context, making people have echoes of Google Spain and the Google Spain judgment. But before going directly to that and some reflections on that, I want to fast forward 10 years from the mid-80s or late 80s to this e-commerce directive and the so-called data protection clause. What did this mean in 1998 when the Commission first proposed it? This directive shall not apply to questions relating to information society services covered by data protection. Well, I think it meant what was on the tin, that control and the concept of controller and the internal market within that was covered already on online services, and we see from the decisions in terms of the roots of data protection, of course they were covered, and the ECD was not to interfere with that. It was meant as an absolute exception. But whereas now, and even possibly in the NT1, NT2 case, this potential data protection exclusion is seen as kind of like a god from the machinery. Suddenly, for no real apparent reason, data protection is carved out from this intermediary shields. That was not what was going on. What was going on was that when in 1998 the Commission originally thought this scheme up, they weren't thinking of intermediaries like we think now, of very active pushing and pulling of content and huge elaborate mechanisms to create value out of that content, but we're only hosting content. No, they were talking about very technical, very passive activity, which would mean that the entity would not be a controller, even in the broad sense that I've gone through with the French Minitel. So, for example, the most active, if you like, the most involved of information of the intermediary shields would be the host shield. And yet, the host shield was only to cover a service that consists in the storage of information provided by a recipient where there is no authority or control at all over that recipient. Well, that doesn't cover an entity which is subjecting to terms and conditions and user accounts, and you're meant to be doing this, that, and the other. No, the example given in the white paper was the provision of server space. No idea what's on this server, but I'm providing a server space for bulletin board services, news groups, or whatever. No indication that the bulletin board or the news group itself would be a host. It was the provision of the infrastructure that was covered, and that's not a controller. So it was seen as compatible, perfectly compatible, to just make clear that the Data Protection Directive was the area of application for substantive data protection. It cohered with the scheme. Okay, so does that mean that in fact Google Spain is not at all the sort of activist, expansive decision of data protection that we think of it as, but in fact is a great limitation of data protection in the online space? Well, in principle, you could run that argument, and it would be in theoretically a pretty convincing argument. Because in paragraph 38 of the judgment, the court said that a search engine, even though it would cover being a controller according to sort of old-style traditional analysis, for some reason only had to act as a controller when it significantly and additionally was affecting data subjects compared to initial publication, which has been interpreted narrowly by Google to mean that they only have to bother about name searches and they don't need to bother about any other form of processing and impacts on individuals. A questionable outcome, actually, even in the terms of what the court said in this paragraph. And even when they did have that significant and initial impact, the court said, they only had to act within the framework of their responsibilities, powers, and capabilities. Is that meant to suggest that the ECD could be applicable here? I don't know, but it's certainly been interpreted by Google to mean that they only have to act after the event on the basis of specific URLs which are specifically justified. Well, this is very, very far away from the sort of active responsibilities of being a controller that are the norm of being a controller and certainly were required by the French Data Protection Authority. I don't know how they managed to enforce it, or whether they managed to enforce it, but back in the 1980s even. But that's only half the story, because that's the principle, that's the doctrine, that's the theory. In practice, of course, we know that Google Spain has been the precise opposite in a practical sense. Internet search engines, up until that time, had been merrily carrying on irrespective of data protection. They had been paying no attention whatsoever to the fact they might be a controller for decades. And this judgment said, no, actually, you do have data protection obligations. And in fact, it resulted in the internet search engines sitting up and listening to that. And in that sense, it was an important sword for data protection. And the second issue which makes the story more complex is, as we all know, and it came up in the first session, considerable amounts of case law have developed since the ECD, suggesting that all sorts of services are covered by the intermediary shields, including social networking sites, which is suggested in the Netlog decision, and even internet search engines, which have been suggested in numerous decisions, but I've just put one there. So that complicates the picture. And to add a further crease, I now want to come back to that issue of the ambiguity of the original understanding in the ECD anyway. Because whereas in 1998, when the Commission first got its teeth into this issue, I'm quite convinced that they really did only mean the provision of infrastructure. As the debate went on and the directive moved towards finalisation, people did bring up, well, what about these bulletin boards? What about these news groups? What about these? And they were put under the language of active hosts. Shouldn't they really be covered by protections? And maybe they should. I'm not saying as a policy matter they shouldn't. And in the Travo of the e-commerce directive, which, by the way, we will be putting online quite soon on the CIPIL website, so you can look through them and see for yourself, Germany, Greece, and possibly some other delegations did say to the Commission, there's a problem here. And the Commission said, oh, yes, maybe there is. We'll go away and we'll reformulate the host provision in order to cover active hosts, or make clear that active hosts are covered. Well, that reformulation never took place. So there was no reformulation of that provision to say that active hosts were covered. And maybe if they had been, this whole issue of what sort of liability rules should apply would have been looked at more closely. And also the data protection exclusion maybe would have been re-looked at, and maybe it wasn't entirely appropriate. But in the context of active hosts beginning to be looked at, the whole duty of care analysis also came to the fore. Well, if you're going to include hosts in possibly a bit broader way, then it's very important that they are duties of care which continue in play. And this, of course, landed in recital 48, the duty of care recital, which said that the directive does not affect the possibility of requiring service providers who host information to apply duties of care which can reasonably be expected from them, not only to take down content, but to detect illegal content in the first place, to monitor. You can't detect without any form of monitoring, and then take steps to prevent ex ante, not just ex post, that illegality. So an idea of a sliding scale, that if you're going to expansively interpret intermediaries, you need a sliding scale of responsibility, which of course brings us back to the hate speech provisions, the copyright provisions, the child protection provisions today, which seem to be going back to that earlier debate and trying to fill out what that sliding scale might look like. So does the GDPR do likewise? Well, we know that the GDPR is particularly ambiguous in terms of what it means. It's not specified at the sort of level we might hope for. But yes, it might, because there's a provision in there which now seems to be saying that the intermediary shields may have some kind of role in the data protection space, albeit the e-commerce directive will be updated to say it doesn't have a role in data protection. But maybe there's an idea there that you shouldn't. You should try and interpret these compatibly within the new framework. And the second thing which is there is a general reference to freedom of expression, not just in the journalistic and allied cases that we've seen in the past, but across the board. And putting too many obligations on even very active go-betweens in terms not just of the substance, but the ambit of their responsibility, of course, can have a very considerable impact on freedom of expression, and that needs to be properly reconciled. And I think if you look back at the 1980s decisions, certainly substantively and maybe also ambit of responsibility, they look rather eye-watering from the perspective of effectively protecting free speech. So I'm not going to resolve any of that for you. That's for you to do later on. But what I'm going to say is that whereas we used to in many cases see three silos, they were sort of up in the machinery, freedom of expression and things like this, but then there was down on the coalface two different areas, data protection and intermediary shield law. What we're seeing is a merging, a Venn diagram of these things coming together, where in certain circumstances, not all circumstances, there will be an overlap. Sometimes an overlap between all three, sometimes an overlap only between two of them. But it's in that messy middle that I think we see all of these debates now taking place, and I hope that's a debate we can continue today. So thank you very much.